Very good morning. On behalf of Principal ADG Sir, Additional Director Ma'am, and entire team of NACIN Mumbai, a warm welcome to all the officers of CGST Commissionerates, Customs Formations, and Directorates from across Pan India in the second session of this online weekly series titled The Vigilance Dialogue. Today's topic is Preparation of Charge Sheet and Conduct of Departmental Inquiry, Part 1. Today we have with us Shri Prabhat Kumar, Principal ADG, NACIN Mumbai. Ms. Good morning and welcome, sir and ma'am. Few ground rules for the online session. Always keep your audios and videos on mute mode. If you have any queries, you can use the chat box or raise hand feature available in web so that the flow of session is not disturbed. With this, I will invite Ms. Jyoti Agarwal, Additional Director, ma'am, to address the participants. Thank you, and over to you, ma'am.
Thank you, Meena. Very good morning and welcome to all of you for this second session of the Vigilance Dialogues. As you are aware that NACIN Mumbai has recently started a new weekly series every Tuesday titled The Vigilance Dialogue from 11:30 onwards, with the aim to cover various aspects of vigilance administration to foster a culture of continuous learning and improvement within vigilance organizations, and also to address various issues which during our tenure we come across. The first session, which was held last week, was delivered by Shri Prabhat Kumar, Principal ADG NACIN Mumbai, and this session, the second session on complaints handling and preliminary investigation, again, Shri Prabhat Kumar, Principal ADG, NACIN Mumbai, would be covering. The last session, which was on complaint handling and preliminary investigation, wherein Principal ADG has provided instruction on effectively managing complaints and navigating initial proceedings. The emphasis was on comprehending various complaint types and responding with actions supported by verifiable evidence. Today's topic, preparation of charge sheet and conduct of departmental inquiry, part 1, because the topic is very long, so we have divided into different parts. So this will be part 1, wherein sir will elucidate on the basics of this topic. We encourage you to actively participate in today's online session by asking questions. Your inquiries help us to enhance the interactive nature of the session and contribute to a more enriching learning experience. So as Meena madam has already mentioned, that if you have any doubts or queries, you can put in the chat box or you can raise your hand. And according to my experience, I have seen that vigilance is one topic or matter wherein we do have a lot of doubts, we have a lot of issues, and we want someone to clear that. So this is a time wherein we can go for it and we can ask the questions, we can understand the topic, so that when either as a IOPO or if we are part of any inquiry, we know how to prepare charge sheet and how to conduct departmental inquiry. So with these words, I request sir to kindly start the session. Thank you.
Thank you so much, Jyoti, and thank you, Meena, for choosing the topic for today. So, and very good morning to all the participants today morning. Continuing the Vigilance Dialogue series, where the stress is more on the dialogue part and not on the monologue part. That is why I have specifically refrained from using any kind of slides, because slides distract people and they are not able to concentrate on what is being said or spoken, and they get lost in the slides itself. So my this series that we have started from NACIN Mumbai, the effort is that we should we should be able to answer maximum questions that is there in the participant's mind, and meanwhile explaining the rule position and how to conduct the various activities in the vigilance domain. But again, I will start my session with the disclaimer that please do not quote me that in the Vigilance Dialogue series, Prabhat Kumar Sahab has said like this, so that is how we are doing it in this fashion. You need to consult the rule position and other instructions in this regard. My session will be only to elucidate or to explain from my perspective what is my understanding about the rule position, and that is a disclaimer I want to put again in the beginning. So in the last session, we discussed about the complaint handling, and we discussed about how to conduct a preliminary inquiry for drafting of charge sheet. So in this session, we will be covering more or less the different nuances of the charge sheet, how to draft a charge sheet, what are the basic ingredients of charge sheet, and if time permits, then we will go on the initial aspects of the conduct of departmental inquiries. So as we discussed in the last session, that conducting inquiry, the preliminary inquiry, is wherever the disciplinary authority or any like formation notices certain irregularities happening in that formation, or suppose there is a complaint, or suppose there is an audit para, or suppose there is a vigilance audit and they have found out something, or suppose there is anything, somebody has noticed in the routine inspections. So all these things like put together, if there is a kind of an information, actionable information which has been generated, that there is something wrong when some decision making, or there is some problem in some files, or the way something has happened. So in that scenario, a preliminary inquiry is conducted. It is conducted either by the Vigilance Directorate, the Zonal Vigilance Directorate, their formation, or even the administrative ministry can conduct. So normally in the cases where there is a vigilance hanging, then the Vigilance Directorate get involved. When there is no vigilance hanging, suppose it is a case of absenteeism, suppose it is a case of drunken behavior, suppose it is a case of alcoholism, suppose it is a case of some kind of abuses, or some kind of small fights which is there in the office, or late coming. So administrative issues. So then it will be covered only by the administrative department, and vigilance will not be roped in these situations. So somebody had asked me a question sometime earlier, that like we appoint some retired officer as inquiring authority for conduct of the disciplinary proceedings. Can we also rope in some retired officer for conducting of vigilance preliminary inquiry or anything like that? So in this scenario, the circular of DoPT is very clear that we cannot employ a retired officer for conduct of any vigilance inquiry or investigation, because since the officer has already retired, and if he is not able to appreciate the things properly, and suppose somehow the vigilance investigation gets vitiated on any account, then government cannot hold that person accountable in that. So though as an inquiring authority, a retired person can be employed, but not in the capacity to inquire into the initial complaints for conducting preliminary inquiry. So now coming to the basics of charge sheet. So why do we need to give a charge sheet? That's the first question anybody can ask. So as we all understand that it is a quasi-judicial function, the departmental inquiry or departmental proceedings are quasi-judicial functions. As we do the adjudication in our own department, that's also quasi-judicial function. So as in our own departments, before we charge anybody, any SSC, that they need to pay so much of duty, so much of interest, and so much of penalty. So in that situation also, we are issuing them a show cause notice. So that is the basic requirement. If you are following the principles of natural justice, which is the basic tenet of any kind of quasi-judicial function, so you need to issue a charge sheet. Now the thing is that what is the constitutional backing for the issue of charge sheet? So in that case, you need to go to Article 311(2), 311, and then sub Article 2. So there, this constitutional backing is there that before any action is taken against any government servant, so we need to first make them aware about that what are the charges on which the government is proposing to take any action. So 311 is the protection that is given to the government servant. But please also read 309, where the government is empowered to, president is empowered to frame certain rules and all that. And then also read 310, where every government servant, which is like appointed by the president, is there is a doctrine of pleasure, that all the government servants will be working as per the pleasure of the president. That is why you see in all the case of presidential appointee, whenever any orders are issued against the person also, then also it is quoted that the president is pleased to do certain acts. So 311 is and 1 and 2 both are the constitutional guarantees given to the civil servants so that it is for their protection. Now you understand how things are shaped up. There is a conduct rule for the departmental officers because it is common to everyone. All the civil servants who are under the appointed under the government of India and who are the presidential appointee or otherwise who are covered by CGST rules. So there is a conduct rule that everybody has to follow. Conduct rule is almost similar for almost identical for everyone. Whosoever joins the government department, central government department, it is identical for everyone because it is against your general conduct that you will not take dowry, you will not take bribe, you will not create disproportionate asset, you will all intimate about the asset, you will not be absent, you will not be having a drunken behavior in public, you will not do this, you will not do that. So a kind of set of conduct, because as government servants, we are all representing the government, and government cannot be seen in a manner which is unbecoming of a government servant. So then that invites a kind of charge sheet. So similarly, apart from the conduct rule which is common to every government servant, the government servants are working in different departments, and these different departments are regulated by different rules and procedures. There is a different act also. There is a Custom Act, there is a CGST Act, there is customs rules, there are CGST rules. There are different kinds of rules, circulars, notifications, guidelines. So when officer is performing their duties under those rules, so even those rules have to be adhered to by the concerned office. So any violation either in conduct rules or any violation by the stipulated rules or act or regulations or procedures prescribed for doing certain thing in a prescribed manner. So if somebody deviates from those rule positions or the procedures, then they invite some kind of stricture or some kind of problem, and then the role of the vigilance or the administrative department come. And both these things, now how will you take action where it is all codified? You all know it is codified under the CCA rules 1965. So that is the place under which everything is codified, that if somebody is not acting as per the not behaving as per the stipulated norms, or they have violated the conduct rules, or they have violated the department's rule position and the act and their procedures, so then they will be taken action against. And how will that action be taken is prescribed in CCA rules 1965. There are penalties, as I mentioned in the earlier session also. Rule 11, they contain the penalties, the minor penalty, the major penalty. There are 10 penalties, 5 minor, 5 major. So there is a rule for suspension, rule 10, that if somebody has to be suspended, if you are contemplating a kind of disciplinary action against a person who are wanting to issue a charge sheet, especially major penalty charge sheet, and if you want that person should not be there in the scene to tamper with the different records and evidences, and they should not be able to influence the witnesses in this case, So you suspend the person. So that is also governed under Rule 10. Penalty is Rule 11. And then, as I had mentioned last time also, Rule 14, Rule 16, Rule 14 for the major penalty, Rule 16 for the minor penalty, and Rule 19 if you want to summarily dismiss an officer if he is already convicted in a court of law. Then there are Rule 24 for the appeal and Rule 29 for the review or revision. So this is the major rules of CCA rules which we all government servants should definitely know. Now coming to the charge sheet. So once a preliminary inquiry has been conducted and once it has been found that the officer has really been involved into certain kind of behavior and he has violated certain rules and regulations and there is a need for the person to be charge sheeted. Firstly, let me just mention what is a charge sheet. So a charge sheet is nothing but a sheet containing the charges. That is why you see in the case of major penalty charge sheets, there is a memo. Memo is mostly of one page only that the president or the undersigned, the disciplinary authority writes like that, wants to issue a charge sheet and there are annexures. So there is annexure 1, annexure 2, annexure 3, annexure 4. So there are 4 annexures. If it is a major penalty charge sheet and which is like depends upon the gravity of the offences. So the disciplinary authority decides that where the officer should be charge sheeted. So what is the charge sheet that they should prepare? Major one or minor one? So depends upon the offences and the gravity of the offences that what has been done. So that is how and how serious is the offence and how you want to penalize the officer. If it is a case of suppose bribery, if it is a case of disproportionate asset, if it is a case involving taking of pecuniary advantages and all that, then in that situation only a major penalty charge sheet can be issued. Nothing else. So what happens is that before the issue of charge sheet, this preliminary inquiry report is put up to the concerned disciplinary authority. And the disciplinary authority takes a view whether prima facie the allegation contained in the complaint or it has come from some other sources are substantiated or not substantiated. If they are substantiated, if there is a case that yes, whatever has been said in the complaint or whatever has come out after the preliminary inquiry, there is an evidence, documentary as well as through the statements given by the various other officers who have been connected with that case, that so and so has done such and such things over here. So then the officer needs to be penalized. So then the disciplinary authority comes to a tentative view that in this case we must issue a charge sheet either for minor or for major, and then they are required to take the advice. So as I mentioned earlier, in the case of the vigilance angle complaint or investigations or inquiries, where the integrity of the person is involved or where the person has taken some kind of pecuniary advantages or where person has done certain things which are not expected to do, either he did or he did not do consciously about it. So in that situation, the department or there is a procedure of consultation. Because why there is a procedure of consultation? Because disciplinary authority should not take any kind of vexatious or arbitrary action against their own officers. Suppose I do not like somebody's face, then I should not be in a position to take action unilaterally on my own. There has to be an independent agency involved. So especially in the vigilance cases. So in the case of residential appointees, as you all know, there is a system of consultation with the Central Vigilance Commission. So the department, after taking all the documents on record, the preliminary inquiry, and even in the preliminary inquiry, it is mandated that the charge officers or the person whom you want to charge, that officer's version should definitely be there, should be taken at length. and then you should be able to come to a conclusion prima facie that there is a case and we need to charge sheet the officer. Then along with all these documents which is relevant for the case is sent to, suppose if it's a presidential appointee, then to CVC for first stage advice. So first stage advice comes before the charge sheet. Before the charge sheet is the first stage advice. If it is not a presidential appointee, if it is not a Group A officer, suppose it's a Group B, Group C officer, then in that case, these days the zonal DGOB needs to be consulted, and we need to send it to the zonal DGOB for getting their opinion. So that is a normal scenario at the moment in our department, that if it is a case of a presidential appointee, that means Group A officers, then we need to consult the CVC, and if it is a case of Group B and Group C officer, we need to consult the zonal vigilance directorate in the concerned zone. If it is a composite case where Group A is also involved and Group B is also involved, then as per the directions of CVC, the composite cases have to be referred to the CVC only for their first stage advice. So once the first stage advice comes, then at that time the charge sheet is going to be prepared.
I would have my speaker, no?
But beforehand only what happens is that when you are sending the case to CVC or to DGOB, they always say and they suggest that you please send the draft charge sheet also. So you need to draw a charge sheet at that time. It is issued later on after consultation, but when it is being sent for consultation only, it is insisted that you send a draft charge sheet, because at that time only the commission wants to see, or the DGOB wants to see, that what are the charges you are drawing against the officer, and what is the kind of evidences you have, and what are the kind of different listed documents and the witnesses you have. So in the case of major penalty, as I mentioned earlier, the charge sheet has 4 parts to it. And the 4 parts are, first part is the article of charge. Second part is the statement of imputation. The third part is the list of documents. And the fourth part is the list of witnesses. The point that is, why do we have article of charge? Why do we have statement of imputation? Why do we have listed documents? And why do we have the listed witnesses? Why it is little different than in the case of the departmental so-called notice? You see the departmental so-called notice, what is the statement of imputation here? It's basically the so-called notice. And in the so-called notice also, we provide or we annex to it the different documents through which we are going to prove that there is a tax evasion and then the tax demand has to be made. So there is a listed document there also. And there is a listed, during the departmental investigations also, we take so many people's statements. That those statements are also part of the so-called notice. So there also we have the list of witnesses in that case. So similar to that, with the only difference that here annexure 1 is taken to be the articles of charge. So it is made so that by looking at the article of charge only, one can understand that what are this officer has been charged on what counts. So in the charge sheet, in the articles of charge, there can be several articles of charge. It need not be only one article of charge. Suppose I will give you an example that an officer came to office late. He was coming to office every day late, and he had been given some kind of like memorandums earlier also, memos that you should be advised to come in time and everything. And one fine evening, one fine day, he comes very, very late, and the senior officer gets bugged up, and then he asks for the explanation again. And then they say, no, this is enough now. Now we need to start a charge sheet against the officer. And when he is scolding or he's telling things to them, whenever, so then the officer concerned starts raising his voice and creates ruckus. he abuses the senior, or even he is having some kind of a brawl with the other fellow officers. So now there will be different articles of charge here. One will be regarding the late coming. One will be regarding the abusive behavior. One will be regarding the brawl that he had done with the fellow officers there. So just like in the criminal case, you see, if there is a robbery, if there is a murder there, if there is a forced entry, whatever. So depending upon the number of events happening in that process or concerned with that employee. So depending upon the management can think of giving framing the different articles of charges against that person. The one thing which is very much required to be mentioned here when we frame the charge sheet is that the articles of charges have to be very, very definite. We need to mention the specific charge there, because what happens normally is that people are mentioning very in absurd or I mean, they do not mention the specific charge what is happening. Sometime I have read from the like charge sheet where a person has been charged that it has been learned or it has been complained that the officer has been indulging into taking of small bribes. Up now the question is that he has been charged with the small bribes, but neither in the article of charge or not nor in the statement of imputation any details have been mentioned that when he has indulged into that, with whom he has indulged into that, what is the amount of the bribe he has taken, on which date, from which person, from like who has complained. So I mean, you cannot give any kind of unambiguous charges. If the charge sheet is containing unambiguity, it is ambiguous charges. Ambiguous charges are containing there, specific details are not there, then there are plethora of judgment of Supreme Court where charge sheets have been quashed and the officers have been given relief. So the point is, the charge sheet, the charges have to be very, very specific, very, very definite. Like I will give you an example that Mr. So-and-so, while being posted in such and such formation as such and such rank, has done such and such thing on such and such date. So this is how the article of charge should read correctly. In one line, in one, like anybody having a normal intelligence, normally in the business parlance, what we say is that we are expecting that if a person of class 10th or 12th standard student, if he reads the document or she reads a document and is able to understand, then that is the correct level of the language, what it should be. That anybody, any third party who is not connected with the case at all, who has the average intelligence of a 10th or 12th class person, and if they're able to understand that what is the charges being alleged against, then you are successful in drafting a good charge. So, like how to draft a charge sheet? If I say so, what people should do is that people should come up with a kind of a blank paper, and then they should list out the kind of offense that the officer has done. So offense 1, offense 2, offense 3, offense 4, whatever it is, and then in the third column they should try to list out the documents, that these are the documents which prove this offense, or these are the evidences which prove this offense. And then in column 4 they should write that these are the witnesses, or these are the people whose statements are important to prove these charges. So if you are able to summarize it in a sheet, and then on the first column you write about the thing, that what is the actual offense that he did, or how to write a article of charge. So there is no limitation in, that how many articles of charges should be there in the ideal charge sheet, in a charge sheet. It can be one, it can be many, depending upon the kind of offenses that the person has done. Suppose he has taken a series of decisions in series of different files. Then rather than putting all the all the allegation in only one article of charge, you can have sub parts to it, or you can have multiple charge sheets to it, that in this file this way, this file this way, this file he did this file he did this. So the number of articles of charges can be many. Subsequent to that, like in the statement of imputation, you need to, the department or the disciplinary authority need to prove each and every charge prima facie using the help of different primary or secondary evidences available, the documentary evidences available. They should be able to quote from the documents properly that in such and such file, such and such document, such and such letter, dated so and so, in para so and so, in page so and so, it is like this. You can also cite those documents in italics over there. Just like we prepare a super notice in our department, in the same manner, we need to quote. Why I am saying, why let us not mention only the document number or the file number? Because then for every detail, then the person needs to look into those documents in detail or those. So that will be a problem. So my suggestion is that if you are drafting a good charge sheet, then after drafting the article of charge should be drafted the last, because that is the language has to be very measured, and it should be able to tell you the offense which is being charged against the charge officer in a very definite and a specific manner. So I will first say that you first come to the different kinds of offenses that the officer has done, and let us make a statement of imputation first. So there all the events are mentioned either sequentially or in any other manner, whichever you want to, but please prove every charge, try to prove the charge prima facie in the statement of imputation using the evidences available. Here I will definitely say that we should not be doing any kind of guesswork, not be giving any kind of any kind of surmises here, that it is presumed. No presumption, no guesswork, no surmises, nothing. Whatever is there in the document, in the evidence, that should be only relied upon in drawing up this statement of imputation or the article of charge, because the article of charge should prima facie appear that the charges are proved from the department side. Then only, because you see, whenever you are charging any officer, you are trying to really put the officer into a kind of a trouble. He will not be getting his promotion. He will not be getting his proper posting. He will not be getting trainings in that period, and he may be under suspension for that period, perhaps. So until and unless we have specific charges against the person, which is prima facie appears to be correct, we should not be starting disciplinary proceedings on whims and fancies. Sometimes people do, but that is not a correct situation in the department. We must avoid doing such kinds of activities, because we are dealing with our own officers, and we need to be little more what I can say objective, without and this toughness. I think you cannot just work upon the passion and you can just issue charge sheet against the officers. So we have to see the evidences very dispassionately. That is why the responsibility cast on the shoulders of the vigilance officers and on the disciplinary officers is huge, because you have to really be detached and then see and then look into it that what we are doing is correct or not correct, because it will put the officer into a lot of hardship. So we need to see from that objectivity before we start any kind of proceeding against any officer. So now coming to the point. So in the charge sheet, so in the charge sheet, I think somebody is speaking on the thing. I will suggest you to please mute yourself until unless you want to ask a question. You can raise a hand. So it will disturb the flow unnecessarily. And okay, thank you. This custom Sultan 1964. Can I request you to please mute yourself? Okay. So the point I'm trying to make is that we need to have our statement of imputation, and we need to use the evidences correctly over there. We need to say put up like whichever are the primary documents which prove the charges should be put first. Then we have to use the statements, and statement should be taken from which person? When we are conducting a preliminary inquiry, who are the people who should be giving the statement? Anybody who is concerned with that dealing of that file, they are the people primarily. They should be there to give the evidence that okay, this is what happened, this is what happened, this is what happened, this is why I wrote like this, this is why I wrote like this, and that is how the statements are taken. And in this like in this fashion, so we need to go offense by offense, like how many how many times the person has not worked as per the stated position or as per the stipulated rule. So we need to go one by one and then create that statement of imputation using liberally from the primary sources of evidence, quoting them in our statement of imputation, so that primarily it is the fire safety, it is proved by using this thing statements and the documentary evidences. One in the list of witnesses, whosoever statements have been taken, and if those statements are really proving the guilt of the officer, that should only be taken. Not necessarily that all the statements that have been taken during the preliminary inquiry should always be incorporated only in the charge sheet. That is not required. And one more thing I would like to mention here is this, that the investigating officer who has conducted the preliminary inquiry, if that person is also made a witness, then your charge sheet becomes true. Why I say so is that he is the person who has done the investigation completely. So if he is also presented as an witness during the departmental inquiry, then and he should be presented in the last, then he as a witness can really put everything threadbare before the investigation, before the inquiring authority, and he will be a big help in proving the charges. Similarly, I would like to say that suppose there is an inquiry by DRI. Suppose let us say that it's a customs case and there is an inquiry by DRI. So DRI has conducted the investigation, and suppose you are going to charge sheet an officer on the report of DRI that we did this investigation and we found that these officers have flouted the rules, or they have not followed the act and the rules and procedures in such manner. So here, please hear me very this thing cautiously. Here I will say that until and unless DRI has made or charged these officers and made them co-notice in their so-called notices, then if we start a charge sheet on that basis only, then our charge sheet will suffer from some kind of lacuna. Later on, the person can get relief, because many courts have held like that, that suppose the DRI was conducting an investigation and the officer concerned statement was also taken, and then if DRI has not made the person as a co-notice in the DRI charge sheet, in DRI so-called notice, that means DRI has not found any kind of violation on the part of the officer. So if our charge sheet is based on the DRI investigation, then primarily DRI should have also found out that yes, this officer has flouted these norms. So then in that case, DRI should have definitely made that person a co-noticee in the DRI so-called notice. Then our vigilance charge sheet will be absolutely like on a solid ground. And then in some cases, what I have, like I was working in DGOV North Zone, in some of the charge sheet that has been issued during my time, I had also put in the investigating officer of DRI as the witness in the departmental charge. Why I did it? Because the investigating officer of the DRI, he knows the case threadbare, because he was the IO in that case. So if he presented as a witness before the inquiring authority, so if there are any gaps happening by any of the other witnesses, that gap can be covered very well by this DRI, because he has seen the entire investigation and he knows the entire evidence very, very well. So that is a very good strategy of keeping such persons as witnesses in the list of witness. Normally what people do is that whosoever is concerned with the case only, they are being put as a witness. They do not put any investigating officer or the preliminary inquiry person as a witness in that. So, but my suggestion will be, and it is allowed. It is allowed, and the other it should be advocated. Similarly, I will say in the case of suppose GST, in the case of GST, DGGI had issued some show-cause notice, and they have also noted that our officers have not done certain things. So in that case, it is always better. It is better that DGGI should have also made our officers as co-notices. Then if on that basis we are drawing a charge sheet on the basis of the DGGI investigation where he is a co-noticee, then we will be able to justify the vigilance case very, very strongly against the charge officer. That you see already department has conducted an investigation and they have found that they have not done certain things expected of them. So that's a good strategy always. But suppose DRI, there is no DRI investigation, there is no investigation, but department on itself has found out on inspection or on some kind of audit or on some happens that am I audible right now? It's saying I'm getting disconnected.
Yes, sir. Yes, sir, you're audible.
Okay, very good. Very good. So the point what I'm trying to say is that if there is an investigation by DRI where the officer's role has been concerned, has been found, and then if DRI has referred that thing to the department, then it is advisable that in the show-cause notice, DRI should make these officers as co-notices. So on that basis, if we issue the charge sheet, then the charge sheet is very solid in that sense. So now, coming to the charge sheet of the minor penalty, I was talking about the major penalty at the moment. Now I talk about the minor penalty. Acha, just to mention, what is the rule under which the charge sheet of the major penalty is issued? As I mentioned, that rule 14 is the rule under which the major penalty is being dealt. So rule 14, sub rule 3. Rule 14.3, under rule 14.3, we are mandated to issue the charge sheet to the charge officer. In the case of minor penalty, the charge sheet is issued under rule 16, sub rule 1. So 16.1 is the rule under which we are issuing the charge sheet of the minor penalty. So in the case of minor penalty, the charge sheet is not as detailed as that of a major penalty. So there are no 4 annexures. There are no article of charges, no section of imputation per se as such. There is only one paper which you can call as a statement of imputation, like the Annexure 2. Annexure 2 of the major penalty charge sheet under Rule 14, a similar document should be drawn. Here also I will suggest that from the relevant documents, whatever you are inferring or whatever evidences are being taken, the document should be quoted, and below that in the italics you can mention that what has been taken from there. So Rule 16 charge sheet, the minor penalty charge sheet, should be like a kind of a document which is like a statement of imputation, but without the list of list of the documents or list of witnesses, without the articles of charge per se. Here also the memorandum is issued the first page, and as an annexure there is a statement of imputation being issued. So this is the difference between the two kinds of charge sheets. Okay. So it all depends upon like what is the offense and what is the gravity of offense which is to be taken. I would like to say one thing. Suppose one there is one officer against whom a dowry case has been registered by police. You know, there is a dowry case, and they have filed a charge memo, a charge sheet in the court of law. Then, should in that case we should issue a charge sheet or not? We should definitely issue a charge sheet in that case. And under Rule 14 only for major penalty charge. So there are many other occasions also, like last time also I mentioned that in the case of bigamy and what should be done. Like today, like suppose there is a case of what I can say, stealing against some officer. Suppose somebody has stolen certain things from the office and taken to home. So in that situation, what you will do? How will you prove that the officer has stolen it? If you have evidences to prove that, if the CCTV cameras to indicate that if there are certain things, he was a custodian of certain things and those things are found missing, then you can utilize that. But suppose there was a case which the Vigilance Department was given to investigate way back. It was regarding like gold. Gold has been stolen from the airport. So now in that scenario, I was just sharing this case as just kind of indicative that what are the pressures that sometimes vigilance officers face. So the case was of stealing of gold from the airport. Now the vigilance was told that you have to get investigated and issue charge sheets. Now tell me, gold has been stolen 10, 12, 15 years earlier. If the vigilance officer has been given the charge that you now investigate the case and find out the culprits, how will you find out the culprit? We have taken out the list of all the people who were the custodians of the gold and who are the people who have taken the gold to the courts. So there is a list of 200 to 300 officers, because right from the seizure made to the present date, whosoever has been there, we have drawn a list of all those officers. Now, if you call those officers and ask about whether you have done this, whether anybody will admit that, no one, because in the vigilance, you are not using any kind of police powers. You are not using any kind of force here. So if you are asking somebody, and it is also a case that people cannot be forced to give evidence against themselves also. So nothing will come out. So then I suggested the competent authority that in this case, until unless there is a police investigation or the CBI investigation, and if they do not find out who are the people who have stolen the gold, then till that time the Vigilance Department cannot do anything, because until and unless we find that the person who stole gold is a government servant, he is our own employee, till that time you cannot file a charge sheet against person. Suppose it is somebody who is a thief. That person has stolen the gold from there. So he's not a government employee. So you cannot issue a charge sheet. So I said that until unless there is a police case in this case, either the police or the CBI, they do the criminal investigation. So until unless they do the investigation and they come out with a situation that in such and such case, these are the people involved. So these people can be taken to task by issuing them a charge. Until unless you cannot. So similarly, there is a police case somewhere. Until unless you get the police report or you get the copy of FIR and you think that the FIR itself is like sufficient at the moment to start a vigilance case, then you can very well do that. Now, coming to like the level of proof, it is very much discussed that what is the level of proof in a case of a criminal case and what is the level of proof in a departmental proceeding. So all of you must be aware that in a criminal case, the level of proof is guilt beyond the hill. That means beyond reasonable doubt, there you are able to prove that the person is guilty. But whereas in the case of departmental proceedings, the level of proof is the preponderance of probability. That means most probably this must have happened. Most probably. So if the probability of happening certain things is very high, then only that evidence can also be considered in the departmental proceedings. So normally what is said is that suppose you are having a straight line and then there are certain dots coming there and then there is a line again. So for like connecting those dots, you can extrapolate the evidences which you have got, but only to that extent, not to the extent that you are drawing an imaginary line yourself only. As I mentioned earlier, though the level of proof required is the preponderance of probability, that does not mean that we are thinking that this should have happened, or conjectures or surmises or our guess. There is no scope of guess here. What I can say is that there is an evidence coming, then something is missing, then again there is something coming. So we can join those dots together, but nothing beyond that. It cannot be a completely imagined kind of charge against an officer. So that should not be done. So charge sheets under Rule 14 and 16 are issued in this manner. Acha, once we get the advice of the concerned authority like either CVC or the Vigilance Authority, General Vigilance Directorates thing, then the charge sheet is issued. So until unless we get that thing, suppose there is a kind of like CVC is not agreeing or the Vigilance Directorate is not agreeing on certain things, then in that scenario, so that in that scenario also you have either we need to CVC. Suppose we are saying minor penalty. The department has sent a case to CVC for minor penalty, but the CVC says no. In this case, the case is very serious. The offence is grim. In this case, we should issue a major penalty. So ultimately, it boils down upon the disciplinary authority only. What is the view he is going to take? So the view of the disciplinary authority is very important. So DA's view, CVC is only an authority to be for consultation purposes. Their advices are not binding completely on the department. In some cases, some mechanisms have been suggested that the case, especially in the case of CBI cases and all, then the matter is referred to DoPT, and through DoPT it goes to the highest authorities, and whatever advice then they give, that is, binding on the officers here. So DA's role becomes very critical. Sometimes you have recommended for major penalty, but a third party like CVC or the Vigilance Directorate say no, major penalty is not warranted in this case, which is very rarely it happens, because otherwise if you are yourself saying major, then they will say major. But sometimes it has also been the case, we have found, we have seen The department says major, but the CBC says no, it is not major, it is minor. So in that scenario, again, DA is the person who has to take the call. But normally speaking, what happens is that DA should not be working independently of all these advices, because there is a mechanism that has been created. It has been for a check and balance purposes. So not necessarily that we need to not take into their advices seriously, because once a formation like TBC or DGOB has given certain advices, the DA must follow those advices and do according to that, because otherwise it creates some kind of problems later on. So here now I would like to invite questions from people, because I have covered primarily the charge sheet under Rule 14 as well as charge sheet under Rule 16, how it is to be issued. Departmental inquiry, perhaps I will take up if I am left with some time here, because the major purpose of this program or this forum is to have the dialogue. So I would like to now have questions from our participants, whatever they have, and it can be from any side, like any topic, not necessarily from issue of charge sheet only, but from anything but what they are facing difficulty. Whatever I have knowledge, I will try to address that. So now I keep I request the participants to ask me questions if they have any. Anyone, if you want to ask?
Madam Chair, he will take. Participants, please feel free to ask any query, any questions you have.
Yeah, Ravinder, please go ahead. Ravinder, you raised the hand, please go ahead.
Hello, good morning, sir. Sir,
Morning,
am I audible?
Yeah.
Sir, my first question is there any difference between charge sheet and charge memorandum, or both are one of the same?
It's the same thing, because in the this memorandum, charge memorandum, the first page you write memorandum.
Yes.
It's a charge sheet only, so it's the same thing. Yeah.
And sir, my second question is uh, at which stage we should start a vigilance file for an officer? Say, for an example, if somewhere the officer has done something and an FIR has been filed in police. So at this stage, we need to start, or we need to wait for the charge sheet to be filed in the court of law, or an investigation report is to be received? Means actually, at what stage we need to start a vigilance case in our department?
Yes, Ravinder, very good question. So here my suggestion will be, until and unless we receive at least a police investigation report, or police has not filed a charge sheet in the court of law, till that time I think we should wait, because just because an FIR has been filed does not mean anything. So what happens is that the moment an FIR is filed, they give an intimation a file is opened. But at that time, till that time, because you don't know anything, because it's a police investigation, until unless they conclude the investigation and they send you a police investigation report, till the time you don't have any evidence with you. What is the evidence? Nothing. At the most, you may be having a complaint, but complaint is having no basis. There is no evidence. And since the preliminary inquiry is conducted by the police in this case, as I mentioned, before issuing any charge sheet, there should be preliminary inquiry. So preliminary inquiry in the case of the police case is done by police authority. So until unless they have given a report to you with proper evidences and whatever list of witnesses and all, till that time you are not in a position to draw a charge sheet. Prashant, you want to ask question? Yeah.
Yes, sir. Good afternoon, sir. Yes, sir. Good afternoon, sir. Yes, sir. Good afternoon, sir. Sir, in cases of where investigation is done by police, that is by filing an FIR, or in cases where DRI is doing an investigation, is it mandatory that we have any preliminary investigation, or can we take the show cause issued by DRI or FIR by police as the preliminary investigation?
Very good question. So, in the case of the police, whatever investigation that they have carried out, okay, that can be taken as a basis. The police investigation report can be one of your like annexures as a listed document. If you really wish to do some more, little bit more in that case, then you are free to do that. Otherwise, like suppose police case has gone, as I mentioned to you, the level of proof in the case of police case is beyond reasonable doubt. But in the case of departmental proceeding, judicial proceeding, it is no, I mean, preponderance probability. So suppose this thing has come to you. Now, if you want to see that there is any other aspect involved departmentally also in that case, well, in that case, you can do a little bit of more investigation or inquiry, and then you can include those things. But more or less, since it was a police case primarily, you will not be having anything in the department. But at least you can see that what is the kind of suppose I'll give you one thing. If there is a case that somebody had met with an accident, car accident, and police alleges that the car belonged to the government servant or to the family. And in your record, you have seen that there is no intimation given regarding that car, either belonging to himself or the family. You can figure out the source of that car purchase. And whose car is it? If it is a wife's car, how did the wife purchase that car? What is the kind of sources of money that she has? So that can be a separate little bit more inquiry here. But more or less, whatever inquiry has been done by the police authority, that should be sufficient enough to draw a proceeding here. Similarly, in the case of DRI. So apart from whatever DRI has investigated from the department perspective, in the sense, what are the violations that they have conducted, the officer has conducted or done or misdeeds. So if something more in terms of some other thing, some other vigilance aspect is also, suppose you have read the investigation report of DRI and you find that there are something more we need to investigate, then we need to get into it. Otherwise, DRI investigation is sufficiently a good source of issuing, suppose DRI has met the officer as co-noticing, then whatever charges have been drawn against the officer, whatever evidences have been given in the DRI report, the same can be taken on the basis of charge sheet. Vijay, Kantheti, JNCH, Vijay, sorry, Vinay, please ask your question.
Good afternoon, sir. Sir, this is regarding a case where the officer who had done misconduct had done the misconduct when he was posted under one zone, and he continued the misconduct when he was transferred to the next zone. So which vigilance section or the CIU of which zone should do the vigilance investigation against him?
That's a very good question. So at the moment, wherever the officer is posted, okay, suppose it's a superintendent level officer. So for superintendent level officer, the commissioner is the appointing authority. Commissioner is a DA also. Okay. So while drawing the charge sheet, commissioner can also call for the report from the other zone where he was previously posted. So even that misconduct can also be like included in the present charge sheet. So wherever the misconduct has been done by the officer in their earlier charges can be inquired into and brought to the present commission, and the present DA, while he is issuing the charge sheet, can include all that, and they can be made into articles of charges. Is that are you happy with the answer?
Fine, sir. Fine. Thank you very much, sir.
Okay.
Sir, Prashant here, sir, again.
Yeah, please tell me one. Yeah.
Sir, in case of one FIR filed by the police, unlike in DRI cases, the statement of the witnesses will not be a signed one. So if we proceed with the proceedings without any preliminary inquiry, will that be an issue in that at later stage where the witness's signature is not there? In the police cases, it won't be there, unlike a 108 statement in the DRI case.
Right. So, Prashant, in such cases, like the department issues a charge sheet, definitely. They also want to like call those witnesses, okay, and take their statement. If they are forthcoming and they want to come and then they want to give their statement, that is taken on record. But if suppose nothing is being done, okay, nothing is being done, then this will be kept in abeyance because the matter will be agitated before a court of law. And in the court of law, suppose the charges are proved and the officer is convicted. The moment the officer is convicted, the Rule 19 is utilized. And under Rule 19, the officer is summarily dismissed from service. So you need not even carry out proceeding also in this case under Rule 14. If there is a conviction of any officer under any,
उसका कॉपी नहीं हमको किधर भेजा है?
if the
डायरेक्ट
officer,
भेजा है ना?
Amutha, please mute yourself.
किसको भेजा है? तू देख, मैं देखती हूँ.
Amutha, please mute yourself. Okay, Prashant. So if there is a kind of a police inquiry and police has filed the charge sheet before a competent court, and we have also issued a so-called, a charge sheet here in the department, then normally it is advised that if there are no witnesses coming, all private witnesses there, so your inquiry will not reach anywhere in that real sense. So it's a criminal case. But the moment the officer is convicted in the court, then Rule 19 procedure is undertaken and then the person can be dismissed summarily from this. Okay.
So,
There
so,
are some
so,
yeah.
so it is better to wait till the orders of the court judgment comes out. Otherwise,
Yes.
otherwise,
Yeah,
if we,
otherwise, how will you do? Tell me one thing.
yes, even if we call the witnesses and they give a statement, a contradiction to the police statements, then it will be
Difficult for you to prove that.
sorry, sir. Okay, sir. Thank you.
Yeah. Some more hands are raised. Some people wanted to ask questions.
Vinay, you have asked question?
Then I have already asked.
Okay. So there is one question.
Naveen was there. Naveen,
Naveen,
Sir, good afternoon, sir. Sir, I have a question. Sir, if CBI has penalized an officer, however, he has not recommended any departmental action and said that the authority will decide where he is posted. So, what was the course of action, sir?
I didn't get your question properly.
Sir, if CBI has penalized an officer in his case and filed a charge sheet, but however, he has not recommended any departmental action,
Right.
not any action at their end.
Right.
However, had said that the customs authority, if he is posted there, can take action. So, what will be the course of action there, sir?
Then in that case, you need to see that what are the kind of evidences CBI has used in their case and the charge sheet in the court. And see, if there is a case of CBI, then obviously there is a violation of conduct rules also in the department. Because either the person has other conduct rule or the stipulated rules and procedures of the department. So there must be a case here also. But then the question is that should we base our charge sheet totally on the basis of the CBI charge sheet only? Or if CBI has not recommended, should we go for a kind of a charge memo against the officer? Sometimes the views are like this, that if there is a CBI charge sheet, then department should also issue a charge sheet. So that if CBI in the CBI charge sheet the person gets released, then at least here in the case of preponderance probability, the officer may be charged, may be taken to task. Sometimes it happens like that the CBI has filed a charge sheet in the case of bribery, and or in the case of disproportionate asset. Then they have recommended it to the department. Now department may need to see that whether those properties or the assets have been declared by the charged officer here in the department or not. If they have not been declared, at least department can issue a charge sheet on those counts. So it depends upon what is the kind of evidence available in the case. department is free to conduct even some more inquiries in that regard or something similar. Whatever CBI has not done, you can do something similar also here in some other files also. You can see what is his intimations, whether there is any other complaint pending against a person. So it all depends upon the situation and gravity of offense in the CBI case. But normally what happens is that if CBI has not recommended any such action, normally department refrains from issuing any other charge sheet in the matter, because whatever was the offense is already covered in the CBI charge sheet and it will be tried in the court of law. If the officer succeeds there, then perhaps there is no point targeting or charging him with a fresh charge sheet in the department. It all depends upon what is the offense, what is the nature of offense, what is the gravity of offense, what is the evidences cited by the CBI. If CBI case itself is very, very weak, and that is how they're not suggesting any departmental action. Normally in a case where CBI charge sheets an officer, they recommend departmental action more or less in every case. So I think we need to see all these different types of like these details before we come to any conclusion. Right, Naveen?
Yes, sir. Thank you, sir.
Next person was raising the hand.
So there is
Mr.
one.
Ashish Rawat.
Okay. There's
Sir, Varun here.
someone is going to ask.
Yeah.
Sir, Varun here.
Manojit. Who is saying? Tell me. Varun.
Sir, Varun, sir. Yes, sir. Sir,
Yeah,
sir
Varun.
my doubt is regarding this vigilance proceeding. What does it mean when we say that there is a vigilance proceeding? My query is specific to the vigilance clearances, which the vigilance section withholds even before the issuance of charge sheets. So is that the right practice, sir, or only after the issuance of charge sheet it should be said that the vigilance proceeding are pending?
So, Varun, you've got a very, very good question that you asked. Normally speaking, what happens is that sometimes if there is like vigilance proceedings are contemplated, like in the case of suspension, Rule 10. So even if you contemplate a vigilance proceeding against an officer and the charges are grave, so the officer is placed in the suspension. Okay. So in the case of promotions, like there are plethora of Supreme Court judgment and plethora of instructions in this case, where it has been stipulated that in the case of promotion, only 3 situations are covered where the vigilance clearance cannot be given. The first is when the officer is under suspension. At that time, the vigilance clearance can be denied. Second thing, if a charge sheet has been issued against the officer, then it can be denied. Third is if the criminal proceedings pending or that means CBI has filed a charge sheet in the court of law, and at that time, or it is criminal proceedings are going on, it is under investigation that time. So in such situations, the promotions are denied to the officer, and only in these 3 situations the vigilance clearance is not granted. But suppose the vigilance clearance is for something else, like for the empanelment of officer in some other department. So in that case, suppose there is a group A officer in our department who applied for empanelment in some other department, then through DoPT or through any other mechanism, in that case, it's not a cadre post. It's not a post where the promotions need to be given otherwise. It's a selection post. So for such selection post, DoPT has come out with a circular. They keep on issuing circular. There is a latest circular also issued in 24, where they have given all the scenarios that in which circumstances vigilance clearance cannot be issued. So you need to get the details of that. If you want, I can share you with circular later on. So if it is a case of departmental promotions, then things are absolutely clear that only 3 situations. It's called Janaki-Raman case, perhaps. So the Janaki-Raman case, Supreme Court has categorically mentioned that either the person is under suspension, or there is a charge sheet it has been issued to the person, or there is a criminal prosecution or trial going on. In that scenario only, they are not given clearance for promotion. And this unclearable case has been then taken the basis, and DoPT has issued several circulars regarding it. Varun, that addresses your concern?
Yes, sir. Just to recap, sir. So it is case specific in the sense the vigilance clearance is required for what we need to understand.
Yeah.
And then we need to apply, sir. Okay, sir.
You asked a question when we say that proceedings have started. Okay. So with the issue of the charge sheet, departmental charge sheet, the departmental proceedings can be said to be started. Okay. And with the order of the competent disciplinary authority, the proceedings are taken to be concluded. Okay.
Thank you, sir.
So it starts with the charge sheet and ends with either charges are proved or disproved, either the person has been exonerated or he has been penalized by any penalty under Rule 9, Rule 11, then the thing is concluded. Yeah, Manojit, you wanted to ask me something? Please read the question. Somebody, Meena. There's some question posted there.
I'll just read.
Yeah,
For Group C officers posted on loan basis in some other formation from his or her parent commissionerate, who will be the DA? If they are in probation period, is charge sheet required? In which cases, without charge sheet, penalty can be imposed directly.
So if the person is under probation, then the constitutional guarantee is given under Rule 311 and 2 is not attractive, because the person is still under probation only. So in case you have found that the conduct of the officer is not proper and it is unbecoming of a government servant, or he has violated certain the offences have been grave in nature. It's not like the case that he has come late or he has been absenting or he did something very minor. So if there is substantive issue, normally speaking, because it should be fair to the people, if they have come after a lot of rigmarole of this appointment process and all that. So if there is a grave offense done by, suppose the person has taken dowry and there is a case against him and police has investigated and has come to you, then there are many other things. Then in that case, person can be dismissed from service without even serving a charge sheet to the person. Until unless the person is confirmed in service after the probation period is over, then only the protection of 311(2) gets attractive. Otherwise, you can just simply dismiss the person from the service. Although the person will go to the court of law and then it will be a long litigation. One officer of a very good service was dismissed from service while under probation, because the charges that was put up against him was that the officer is his efficiency is not good. He is an inefficient officer. Although they could not prove they didn't have sufficient ground to prove the charges, but department dismissed. Then he went to CAT. CAT also dismissed his petition. Then he went to the High Court. High Court also dismissed the petition. Then finally in Supreme Court, then he roped in a very good lawyer and then he contested the case. The Supreme Court gave him relief. So he had to fight for 8 to 10 years before his probation only ended. But then his seniority and everything got restored subsequently. So during probation time, people have to be very, very careful. In one of the cases where a person has been appointed on a lateral basis in one of the formations. So there, I was the person who was investigating that case against him, and he was still under probation. His probation period was going to end in some time while I was conducting the inquiry. Then I had requested the disciplinary authority to increase his probation time by 6 more months, and that they did. And during meanwhile, I submitted my report, and I had found very adverse things against the officer concerned, so that he couldn't have got the appointment only in the first place. So based upon my report, he was summarily dismissed from the service. Despite the fact that he was taken from, like he was appointed through a due process through UPSC and all that. He came at the director level of Government of India laterally. But on the basis of my report, he was dismissed summarily because he was still in the probation period. That is that answers, Manojit, is answering your question? Jyotish, में और क्या question था उसका?
Yes, sir. I think there are no more questions.
I think there was one more part of the question of Manojit.
I think, sir, he has repeated the one more part. So it was, okay, I'll repeat. In which cases without charge sheet penalty can be imposed directly?
So I just mentioned, so penalty can be imposed under following the Rule 19. In Rule 19, if the officer has been convicted in some other case in a court of law, so based upon that, Rule 19 penalty can be imposed. Secondly, in those cases where it is not possible to conduct an inquiry, departmental inquiry, then also the penalty can be imposed. Suppose in the cases where the issue is regarding the safety security of the country, or it is such a secret kind of thing that if it is made into public, it will be a problem in public domain. And in such a situation, even charge sheet is not required; it can be dismissed. And during probation, also the person can be dismissed. So these are the situations where we don't need to conduct even an inquiry. So depending upon the gravity of offense, the type of organization we are dealing with, so that is how it is there. Any more questions? Anybody? Ravinder.
Sir, my question is that, suppose, sir, this office came to know from the newspaper that some officer has done something wrong and CBI or DA has done a case against him. And as such, no formal communication has been received from any of the agency. But meanwhile, the officer has put his resignation. So what could be the course of action at this office level?
So the resignation cannot be decided in one day, na? There is a time period start to have. So in that time period, you will come to know about it. Normally, in such cases, CBI definitely comes to the department concerned with all the action that they have taken against the officer. So if they have not, at least in the basis of that report of newspaper, you can ask them, you can write them a letter that what is the thing that you are doing against, so bata do. They'll come out with it. So don't take a decision on this resignation on one day. That is why a period of 3 months is given. The department verifies each and every aspect that why person is going. Okay. Right.
Thank you.
Anybody else wants to ask a question?
So one more question in the chat box.
Yeah.
Can the suspension period be treated as duty if the officer was acquitted by CBI but major penalty imposed by department?
The moment a penalty is imposed by department, then the period of suspension may not be treated as duty. Let me just say, when do we treat a suspension period as duty? Is that when the officer is exonerated, finally there is no case substantiated against him, then we have treated that period as duty. But if there is a conviction, either in the CBI case or even in the case of the departmental proceeding, because we have drawn a proceeding, and then the person has been found guilty of it. So in that case, treating the person on duty and giving him all benefits will not be a good idea. So that is why if there is a conviction, or if the person has been charged with certain kind of penalty subsequently, then it is better not to regularize that period of suspension in full duty. Some more question was there?
Yes, sir. By Naveen, he has asked,
before
filing the charge sheet during consultation, the person or authority reached for consultation says that the case is not tenable, then as a disciplinary authority, what will be the course of action?
You can withdraw the charge sheet also. That is why what happens is that whenever a charge sheet is issued against the person, then the person, so here you are saying before issue of charge sheet only. Naveen, you are saying that?
Before filing the charge sheet, sir.
Yeah. So before filing the charge sheet only, if the consultation process, they come to know that there are no evidences in this case, then charge sheet is not warranted in this case. Because many cases I have seen where department first recommended major penalty charge sheet. It came to the commission. Then when we looked into the evidences and we raised certain questions against, we raised certain questions in that case and referred it to the department back and told them to answer them categorically. They failed to answer. Then they themselves said, sir, no evidence is sustainable in this case. We withdraw the charge. We do not want to issue charge. So, charge sheet was not issued. So that is why the consultation becomes important, because it's a third party neutral consultation. Some DAs may be biased against certain officers. So they may be trying to vexatiously trouble the officer. That is why the system of consultation has been devised. Any more?
Thank you, sir.
So if there are any no questions, then I'll conclude it here. Then in the next session, we will start with the disciplinary proceedings, in the sense like departmental inquiry, how to conduct the inquiry. So IOPO and the role of that and everything. So that is after the charge sheet only that thing is there. So how do we decide what is the written set of defense? How would the DA appoint IOPO? Who can be the IOPO? Who can be the defense assistant? And then preliminary hearing and all that will start next session. Jyoti can conclude now, I think.
Yes, sir.
So on behalf of the participants and NACIN Mumbai, sir, I thank you very much for the enlightening session. Sir, with your permission, sir, can I request the participants to switch on the cameras so that we can take a group photo, sir?
Please, please, please.
Participants, you may please switch on your cameras. Participants?
Some of you may please switch on. I mean, most of you can switch on, but I could not see anyone. Please switch on your camera so that we can take a picture.
Thank you, sir. Thank you once again, sir. Thank you very much. Yeah.
So next session again on next Tuesday.
Yes, sir. Next Tuesday we'll be having next session on 2nd July.
Thank you, sir.
Thank you, sir.
Thank you, sir.
Thank you, sir.
Thank you, sir. Thank you, sir.
है ना? सर,